Good afternoon, ladies and gentlemen. My name is Mbali Kumalo, and I am a director in the Banking and Finance Department here at CDH. Thank you for making time today to join us in this seminar as we unpack the complexities of asset recovery within the legal framework. As many of you may be aware, this seminar is part of a series of initiatives under the Women and Juniors in Law and Banking program run by Nedbank in partnership with ENS and CDH. Today, we also acknowledge another partner, Worksmans, who will take over the program effective from 1 April and will manage the various initiatives for this year. We express our sincere gratitude to Nedbank and ENS for the continued support during our tenure, and we remain committed to the program and supporting the various initiatives. Without wasting any further time, please help me in welcoming the panel as they provide their insightful knowledge on this. Thank you.
Good afternoon, colleagues. I guess we'll have to start with introduction. I'm Chuma Mtengwane, Special Director of Public Prosecutions attached to the asset recoveries of South Africa within the National Prosecuting Authority. I'm not public prosecutions as written there. I thought I must throw that in. Thank you.
Thank you. Thanks. And good afternoon, everyone. I'm Stephen Powell. I'm the Head of Forensics at ENS, the law firm. And today I'm not going to be giving you the theory. I'm going to leave that to Chuma. I'm going to be giving you a couple of war stories about some of the experiences when we've gone into the homes of these drug dealers and taken their sports cars and frozen their bank accounts. And I'll give you a taste of what it's like. Thank you.
Hello, everyone. I'm Sentebale Makara, dispute resolution specialist. I just solve problems. That's all it is. So usually with Stephen, I'm probably the person that annoys him and asks him all these things for my clients. So I'll just give you an overview of what happens after this, after seizure, what happens after forfeiture.
Okay. Thanks, colleagues. I think the most dramatic person here will be Stephen. For a change, Jacob, I won't be dramatic today, so I'll keep and behave. I see some of my former colleagues here. Colleagues, my role is easy, is to give you a background on asset forfeiture. Internationally, we call it asset recoveries. So I think at some point in time, 1998, the law enforcement of South Africa decided to wake up and realize, we've been doing things the ordinary way, so we need to change and make sure that we have some extraordinarity in what we're doing. So asset forfeiture got to be established based on the Prevention of Organized Crime Act 121 of 1998, which is then the legislation that governs everything that happens on asset recoveries. So, like I said, with the quote, Martin Lloyd-Jones, that's where it comes from. In a time of extraordinary evil, are you doing anything extraordinary? That's when the justice class had decided, okay, let's see how to turn things around. Let's see if we can take proceeds out of crime. Crimes, yes, criminals, we do send them to prison, but what do they do after that with the proceeds of crime? Some, they come back and enjoy them, and then asset recovery was then established. So, colleagues, the rationale behind the asset recovery was just to make sure that crime doesn't pay, and to ensure that, the old conventional ways of dealing with crimes were no longer effective in the modern system that we live in. There's corruption, there's everything. The state capture is the word of the country. So asset recoveries had to be established to ensure that crime really doesn't pay. Asset recoveries is in two folds, colleagues. I won't focus on the slide. I will just talk to you. It's in two folds. There's conviction-based asset recoveries. There's non-conviction-based criminal forfeiture. Now, on the conviction-based, we determined by a person being charged. We'd call it Chapter 5 of the POCA. Chapter 5 deals with three applications. Restraint application, where we make a temporal application, where we worried about dissipation of assets. So we freeze the assets. It's a restraint order, that's how it's called. Then you charged, there's a charge sheet, you go to court, we get convicted, then a benefit is determined. Then there's a confiscation order in terms of Section 18 of the POCA. That happens after conviction. And then later after that, a confiscation is a judgment may sound in money. So if you're unable to pay the confiscation order, then we look at the assets that you have, then we go in for a realization application. Colleagues, I'm talking about assets, assets, assets. Stephen will get into that. Now, Chapter 6 of the POCA talks to civil forfeiture. There has to be no criminal prosecution against you. You wouldn't be charged. There is only an act of unlawfulness. There we target the proceeds of crime and the instrumentalities of crime. So the application is in rem, it's not in person, like in terms of the Chapter 5. The applications there are only two. It's preservation and the forfeiture. All of these, we talk assets, colleagues, unfortunately. So it depends on whatever chapter that we follow, we look at assets. Asset recovery is only about assets and nothing else. When we get a case, we're told that Jacob stole money from wherever he's working, and then we'll look at what did Jacob do with this money? That's my job. I follow the money. If the money has been deposited into the bank account and all that stuff, I need to analyze Jacob's bank account to see what did he do with the money. If I realize that Jacob purchased a property in Sandton with the money, then for me that will be proceeds of crime in terms of Chapter 6. That is a civil recovery. Jacob may not even be charged there. So that's what I look at.
Chuma, can I just ask, is the Jacob you're referring to, is his surname Zuma?
It's that one. So like I said, colleagues, then we target the property there. Those are the non-conviction-based forfeitures. Like I had said, it's the proceeds, it's instrumentality, we call it a preservation application. After 90 days, if there's no opposition to me taking that house as proceeds of crime, we go to a later stage of the application, which is the forfeiture. In between this, there's a house that I've taken from Jacob. Then I need to decide, how do I handle this house? I don't have the capabilities as NPA to deal with people's properties. I don't even have that function that sits with me. Then in my court papers, then I will appoint somebody to look after these assets. That's where Stephen comes in. I decide whether I appoint a curator. If it's a movable, I can appoint an auctioneer to take care of the property. But somebody has to look after the property to ensure that it's safe. If there's opposition, if it succeeds, it must be taken back to Jacob in a fair state, good state, where it was seized. So, colleagues, that's the basis of Chapter 6. Preservation application, and after 90 days, we publish, we serve on the government, publish on the government gazette, we serve, we publish on the newspapers. If there's no opposition, we go to the Section 48, which is a forfeiture application. Then we forfeit the property. When we shall have forfeited the property, if it was with Stephen, Stephen will take it to the market, sell it, and then Stephen takes his portion of his expensive of taking care of the property, and then the rest of the money we pay it into Kara if there are no victims. Criminal Asset Recovery Account. Chapter 6 is an easy process, more especially if it's not opposed. But then the complication comes in terms of Chapter 5. Colleagues, this is a high-level brief so that we don't waste time. If there are questions, I think I'll be fairly okay to answer them. Now, in terms of Chapter 5 is a bit complicated because somebody there has to be charged. Okay? There, the applications I had said is a restraint, it's done in the High Court, and then after conviction is a confiscation order, and then it's a realization application. Then what happens here is that we decide at a certain stage in the assessment of the case whether on the person charged there's a risk of dissipation of assets. If there's a risk of dissipation of asset, we can then decide, once you are charged, as long as there's a charge sheet that has got the elements of an offense, we go for a restraint application. A restraint application is a temporary order just to hold the assets so that they don't get dissipated. Stephen chips in there because there's a variety of assets. More in terms of Chapter 5. He's going to dramatize all the drama there with assets in terms of Chapter 5. There will always be drama in seized assets in terms of Chapter 5 because there's criminal prosecution involved, which takes longer. So in most instances, we do usually, in terms of Chapter 5, looking at the estate, how big is the estate? Is the estate manageable? At times we seize mines. Stephen is going to tell you all of those dramas. We seize businesses. So we need to make an assessment whether should we shut down the mine? All employees lose their jobs. It's South Africa, colleagues, unemployment is very high. So we look at all those things, assess, and then decide. But Stephen will talk to that. So in terms of Chapter 5, it becomes very critical that we have somebody, while the criminal matter is dragging for years and years, we've got somebody who's taking care of these assets, looks after these assets, in any form, in any manner. But that is determined by the assessment of the case. So that restraint, whilst you're going to court, there's infightings between us and the accused in court because the accused is going to say, you've taken all my assets. I've got legal bills to pay. I've got living expenses. I need to live. I cannot live on the legal that is left with me. My business was making money for me. There's certain things that I cannot pay for. Then there's applications that comes in that application, which are called living and legal expenses. It's a big word there, Jacob knows. So, and Stephen will be pulled into these discussions also. Looking at the assets, then Stephen must be able to tell that, can we accommodate this person? Because on the application just doesn't come out of nowhere. You do come to our offices with a lawyer. You do bring in your concerns to say, out of the assets, I would like to have 1, 2, 3, 4, 5, but if we don't agree, then we go to court. But Stephen must be part of those discussions because he must be able to tell us, can we pay for what Mbali is looking for? Can we not pay for it? Is it feasible out of the estate? Or if we have to pay living and legal expenses, what must we do with this block of flats? Must we rent it out? Must we generate income out of the estate that is taken care of? So there's a lot of consideration there. We need to link up with each other. But if we don't agree, the process goes to court. It's a mountain to climb, proving living and legal expenses for defense and the accused and the defendant. It's not an easy task, more especially looking at certain offenses. And you'll have to also consider, what are you asking this money for? Are you asking this money to still continue with a fancy lifestyle? If that's the issue now, then you're not going to get those living and legal expenses. Hard luck. So there's those considerations. If the living and legal expenses are reasonable, then we were able to consider, we don't have to go to court. Then Stephen will be able to tell us, okay, we can release certain funds here, we can release certain assets there, but that's the discussion that we get to have. That's a restraint, colleagues, with all its challenges. And then, after conviction, we'll look then at the benefit. That confiscation application is made in the convicting court. The restraint is in the High Court. It's a temporal order. Once you are convicted, then we'll look for another kind of an order in terms of Chapter 5, which is a confiscation order. That is done, whether the convicting court is the lower court, is the regional court, is the High Court, but it will always be done by the convicting court because there's an inquiry there that needs to be done. The defendant must be before court to be able to determine the benefit. Once the benefit is determined, even confiscations, they get to be opposed. And then evidence has to be led. There's Section 21 affidavits that have to be filed as well. Then we settle the confiscation. Are you able to pay? Somebody can come and pay for you the confiscation because we said it's a judgment sound in money. So if there's somebody who's prepared to pay for me, then Stephen comes and says, okay, I'll pay the confiscation amount. That's okay, that's acceptable. But if you're unable to pay until a certain period of time, then we'll look at your assets. When we get to confiscation, colleagues, everything in asset recoveries is done with assessment. We will not have a confiscation order if we know you don't have assets, in case you are not able to pay in cash. So there are instances where we won't even have to get there, looking at your assets, whether your assets will be able to fulfill the confiscation order. Those are all the assessments that we'll look at. Then if you don't fulfill the confiscation order and you have assets, then we look at another application, which is a realization application. Colleagues, the nice part about Chapter 5 is that as much as it's a tedious exercise, it has got its own challenges, is that in terms of asset recoveries, in terms of Chapter 5, unlike Chapter 6, I'm not targeting the property that you generated out of proceeds. Even if it's your house that you had long time ago, for me, when I want to satisfy my confiscation, I take everything to the value of the benefit. But not in all assessment, the case is going to take you to Chapter 5. It may be an easy, quick Chapter 6. That's the consideration. But in all the cases that we get, when we get a docket, we evaluate and we assess them, which chapter to go for. And you are guided by evidence. You don't stump sack things. So, colleagues, in brief and in essence, that is asset forfeiture. That's what we do. We deal with assets, but unfortunately, when we seize your assets, whether as a provisional order in terms of a restraint or as a provisional order in terms of a preservation, we don't have the capacity as the National Prosecuting Authority to keep assets. In certain Southern African regions, they do have within the government department asset management. In South Africa, we don't have. That is why 90% of the times we use either auctioneers, curators to take care of our assets. But that was a strategic decision that was taken at the initial stages of poker as well, because we wanted to distance ourselves as much as possible from the assets and to have an objective, different kind of a person who's not linked to us to be able to take care of the assets. Remember, when we appoint a curator or an auctioneer or whoever we appoint to take care of assets, we make that application to court. And that individual that is not appointed by us is appointed through the court process. But in our orders, we do indicate that the person, in everything that he does in consultation with, we don't dictate to Stephen what to do. Because Stephen doesn't report to us, and Stephen is not appointed to us, but Stephen is there to assist our process. There are instances where Stephen, they get to be cited on certain litigations with us. They fight their litigation, we fight our litigation, but we make sure that we support each other in the process. Because Stephen is holding those assets for my interest at the end of it all. I don't have to get an empty order. I tried to summarize it as much as possible, but I think if there are any other aspects that you would like me to cover, we can deal with that in terms of questions and answers at a later stage. Thank you so much, colleagues.
Thank you. Well done, Chuma. That was a brilliant summary, and you've covered so much territory in such a short period of time. My role as curator goes back to 1998, when the legislation was first promulgated. I'm probably giving a good indication of my age now, because before that I was a prosecutor. And on my very first order, I was challenged by one of the rogue road accident fund lawyers. Hussein Mohammed and Ahmed Choyan were two lawyers in Cape Town who made a lot of money out of road accident victims, and they targeted particularly illiterate victims who couldn't read or write. And so what they would do is they would motivate for a compensation claim with the RAF. When the claim was paid out, they would call the victim into their offices and they would say, put your X here, and give them a check for 20,000 or 100,000. And typically, the amount that they gave to the victim was 20%, and they kept 80% for administration and their legal costs. And so there was a restraint order granted against Hussein Mohammed, but he challenged the legitimacy of the legislation. He said this legislation is ultra vires. Yes. And we went on 5 different excursions to court, and I'll go through some of those challenges because it deals with the very issue that Chuma was alluding to. As the curator bonies, you've got to manage the estate, preserve the estate, so that ultimately, whether it goes back to the accused or whether it gets forfeited to the state, it gets looked after in the healthiest way possible. And Chuma says they don't dictate to the curator bonus, but the curator bonus is scared of the AFU, because if we're too generous to the subject of the order, they're going to be unhappy. And if we're too harsh on the other side, the subject of the order is going to be terribly unhappy. So Mr. Mohammed was terribly annoyed with me when I had to say to him, we are not going to pay for 3 servants and a driver and a cleaner for your pool. You're going to have to drive yourself, and you're going to have to clean your own pool, and we will allow payment for 1 domestic servant. And the worst one was when his daughter wanted to get married. And he said to me, you know, in our family, and I'm of Indian descent, it is customary to throw a lavish wedding for one's daughter. And so he said to me, I'm going to make an application for the release of some of the funds under restraint in order to fund my daughter's wedding. And I said, send me a request, and if it's reasonable, I'll consider it. And how much did I get for the request? 300,000 rand. So I suggested to Mr. Mohammed that perhaps his daughter should wait until after the order is finalized before she gets married, because I can't release 300,000. Next thing, I was called a draconian monster in court papers, and he challenged that. But fortunately, the judge agreed and said that this was a bit extravagant. We later found out that Mr. Mohammed's daughter's wedding took place at the Lord Charles in Somerset West. And I sent an investigator to go get the documentation, and the response from the hotel was that Mr. Mohammed had asked them to not document anything, and there were no records. He paid in cash. And what I then did is I brought an application to the court and said, I'm not paying living and legal expenses because Mr. Mohammed clearly has access to other funds. He wasn't happy, he challenged that, but the court ruled in my favor. And 2 weeks later, after indicating I'm no longer paying the lawyer's fees or living expenses, he capitulated and did a plea agreement with the state and ended up going off to Malmesbury prison. I had to go and visit him in Malmesbury prison, and I must tell you, after 3 weeks in Malmesbury prison, he was a ghost. He was a fraction of the man he was before he went in. He was withered and grey, and when we called him to come and see me, the orderly came back with a message that, tell Mr. Powell that I don't want to see him. And the commanding officer of the prison said to the messenger, tell Mr. Mohammed he must come anyway. And then he came and he signed the documentation. And he was paroled early, and I must share this story as well, because what happens is we've got to manage the estate and make sure that we always act in the best interests of the estate in preserving the assets. And what happened is we recovered money all over the world. We found $1 million in New York. We found 3 million with Bank of Baroda in India. We found 7 million with an attorney in London. And I had to write to the attorney in London and say to the attorney, I've got a South African court order. I've been appointed to recover assets on behalf of the AFU. We understand that you have funds in trust for his co-accused, Mr. Chohan. And I opened my mail the one morning, a few weeks later, and in the mail there was a check for 7 million. And the attorney had said, if this money has anything to do with the proceeds of crime, I want nothing to do with it, and just relinquished it. I thought we would have a long legal challenge and we'd have to get lawyers appointed on that side to get the court to recognize the order, and it's a cross-border order, so I was very surprised. But that just gives you an indication of how seriously the anti-money laundering laws in the UK function and how well they function. But going back to Mr. Mohammed, when we forfeited assets, what happened here is the Fidelity Fund actually stepped in because we had more than 227 victims that had been defrauded of their funds from the RAF, their claims. And so instead of waiting for the case to be finalized, the Fidelity Fund settled the various victims. And then when we recovered and liquidated the assets, we compensated the Fidelity Fund. And what I also paid over to CARA, the Criminal Assets Recovery Account, it's quite funny, the acronym also is CARA, is the Italian word for my love or my darling. when we paid the money over to Kara, I got a summons from Mr. Mohammed's lawyer, and he had cited me in my personal capacity, and he claimed that I had paid over interest on the funds that we'd accumulated, and the order made no mention of what should happen to the interest. I thought it was quite logical that the interest would go with the funds to Kara, but he didn't agree. But I was really put out, and I phoned his attorney, and I said to the attorney, why am I being sued in my personal capacity? This is not personal. I'm doing this as a job, you know, so it's a role I've played. I don't get the revenue for this. Why sue me in my personal capacity? And the lawyer said to me, Mr. Powell, we sued you in your personal name because we knew it would get under your skin, and this phone call has confirmed that it did. And needless to say, you heard Chuma saying the AFU will have your back when there is a challenge. I phoned at that stage, Willie Hofmeyer was the head of the unit, and he said, don't stress, Steve. We will apply to be joined to the matter, and we'll get senior counsel on board. We'll fight this. And what was really nice, it was the early days of asset forfeiture law, and we were establishing precedent all along the way. So each of the challenge, Willie was actually just rubbing his hands because each time we went to court, we won, and we set new precedents for the asset forfeiture unit. And it was so important to get visible justice, to show criminals that crime doesn't pay. Chuma, and the one thing that I'm missing is the visibility. You guys need to do more about the marketing and the PR to publicize and make people aware that you cannot act with impunity, and if you steal, we will take those assets back from you. And that is quite important for the future. But I'm now going to take you on a walk through history and take you to the very first asset forfeiture order way back in 1998. This was completely new legislation, so it was alien to judges. How can you seize anyone's assets before they've been convicted? So the judges were vehemently opposed to this law. They thought it's draconian, it's unfair, an accused has the right to be heard. And here is this ex parte application from the asset forfeiture motivating to go and seize the toys and nice assets of these drug dealers, etc. And so I got approached to be a curator bonus. It was brand new law, and Billy Downer was my former mentor when I was a prosecutor years ago. And he said, Steve, can you fulfill this role? And I asked a few questions about the role, but nobody knew too much about what was going to happen. So I went in with my eyes not totally open, because what happened is the judge took all day reading the papers before he put pen to paper. Once the judge signs the ex parte order, you've got to go across to the master's office and you've got to get your letters of curatorship. And the masters stayed open after 4, which was a miracle in and of itself. And I got my papers, and by the time we mobilized with the drug unit from the police to go to serve the order on the accused at his home, and this was a cocaine smuggler living in Sandrift in Milnerton in the Western Cape. And we arrived at about 10 o'clock at night, and then I looked around me and I saw that I'm accompanied by my 2 juniors. One was an accountant, the other was a lawyer. And here I was, armed with my pen and writing pad. And we looked at the police, and they had Kevlar jackets and machine guns. And I thought, gee, we need to adopt some improved risk management here. And it got even scarier, because as we got to the house, the police said, Steve, we're going to go in, but we want your team to line up against the wall so that you're out of the line of fire when we open the door. And so we went into the house, we searched the house. You've got to do an inventory of all the assets and all the luxury items, and we have a removal van. You'll remember the early days of asset forfeiture. We used to have vehicle drivers to take away the sports cars. We had the delivery van taking out the plasma screens. Someone used to tip off the television crews, because we had massive television crews outside, and this would all be filmed live as it was happening. And drug dealers are not very happy when these things take place. So we had the first cocaine smuggler. His name was Melvin Bathgate, and he was actually quite a sweet guy. He didn't go ballistic when we served the order, and his attorney arrived very soon after we arrived, and his attorney explained the court order and explained that Stephen's not the bad guy. The bad guys are the asset forfeiture unit. They're the ones that are going to take your assets. Stephen is just independent. He's going to manage the estate while it's under this restraint order, and you need to cooperate, and he did cooperate. He cooperated too well, because after we served the order and we searched the house and we did the inventory, we froze his bank accounts, we send a copy of the order to the deeds office so that he can't transfer any properties, and he had about 4 properties in his name and 3 cars, and when we looked at his travel records, he used to travel all over the globe. He had a pair of girlfriends. He was dating twins. And they were both at the home when we did the order. And it's actually, I don't know if I should tell you this. Are we all above 18?
Yes.
So what happened is the twins were in the house when we executed the order. And I noticed that one of the twins was carrying a handbag tightly under her arm. And every time we finished in a different room, she would walk holding her handbag. And right at the end of the search, and we did find a weapon in the house as well, by the way, that was also quite scary, I said to girlfriend number 1, we're going to have to see what's in your bag. And she said to me, Mr. Powell, I've got dirty lingerie in the bag, I'm not showing it to you. And I said to her, lady, I promise you, I'm not interested in the dirty lingerie. Although I did secretly suspect that the accountant in my team was very interested in the lingerie. And so she emptied the bag, and then there was a sudden hand movement behind her back, and I said, just show me what you've got in your hands. And she pulled out this wad of banknotes, and there was about 50,000 rand in cash. And she said that Malvin said he might go to jail tonight, so this was to tide me over until he was released. So I'm conscious I'm talking too long, but let me just wrap up the story, because 3 weeks later I end up going to Makara, one of my favorite curry restaurants in Cape Town, and I thought the waitress looked very, very familiar. It was one of the twins. I have never had as unsettled a night of discomfort, but I was fine. And I said to you, Malvin cooperated more than I expected, because after the call, he phoned me up and he said, Steve, I just want to bounce off my legal strategy on my criminal defense. My lawyers want to do X or Y, and I had to say to him, whoa, hold on, Malvin, I'm not your lawyer, I'm the independent curator. I'm not here to challenge what your lawyers are telling you, and I don't want to know. But he did cooperate fully. He went to jail ultimately. He did a plea agreement with the state. We forfeited his assets. I had a nightmare trying to get his mistress, another girlfriend other than the twins, out of his property in Woodstock. And we had to get an eviction order. And we got an estate agent to value the property, and we got a buyer for the property. But she refused to vacate the property, and the court gave us 6 months to vacate. And in the interim, the agent lost his sale, and then he sued me for his commission. And I said to the agent, are you crazy? The asset forfeiture will never use your company again. And then I discovered these estate agents work as separate franchisees. They're only interested in their own commission. But anyway, we sorted all of that out, and we recovered the proceeds. We sold all his cars, we sold all his properties, and those proceeds were confiscated and paid over to Kara. I'll tell you more about some of the others later if there's time, but I've stolen enough time from Sentebale.
Not at all. I'm hosting, so I'll indulge everyone to take up my time. But that being said, so where I come in is more on the basis that this client it's all about allegations and allegations and allegations. So it's all alleged at that point in time. So maybe let's start at the basics of the SAPS and the task of investigating. At that point in time, it's usually the good idea to actually start engaging with the SAPS. And through the SAPS, usually once a prosecutor has been assigned, that you actually start the process with the prosecutor of doing inventory, so that you actually avoid a situation of what I would call a akin to a dawn raid in the middle of the night, where there's actually an inventory that's been done. You've disclosed your bank accounts. You've been transparent with the process. So even the process itself, when the court approaches are made, they're not necessarily per se ex parte, because you actually know what to anticipate on it. It goes a long way to try and actually deal with it. So I'll first talk maybe in the times of peace, where you actually are very much aware that you're a subject of an investigation. There's been a bit of transparency, and in doing so, you actually then engage with people and engage with the IO, for example, will then link you with the investigating prosecutor as well, in line with this. When I talk about an investigating prosecutor, usually it's someone that's probably sitting at Hawks level at times. Now, it's a bit mirrored because there's various other organizations that have this task as well of also doing sort of asset forfeiture. I'm talking about SARS, SIU to a certain degree now is also venturing into the territory. So it's not necessarily now an NPA only situation, as although in my view it's still been something that's kind of a gray area, because I've always thought the act is actually intended to be implemented by the NPA and through its arms, the AFU. You see, but we've seen, as many have seen in recent times, with SARS also coming into the play, the SIU also coming into the play with orders from the tribunal. The SARS ones we've debated earlier today as well, that there's big issues with regards to how those actually play out. But the formula for them all are very simple. But at least with the SARS ones and the SIU, you can anticipate that they come a bit more on a friendlier environment, because there's actually an anticipation of it coming, because you can see where it's going. There's a bit more engagement on them. So they're a bit more. But in Chuma's side of things, most of the time, you do get the element of surprise. But even there, nonetheless, as that lawyer that comes in the middle of the night to try and meet Stephen, one of your tasks is, of course, to explain what the person's rights are. But also importantly, to understand what this order says and what they are doing is in line with that specific order. Because the first thing in the morning, your next task, besides getting bail for your client, would be actually to try and now see what they have actually taken and whether it aligns with what has actually been part of the order. But more importantly, there's something that Chuma also mentioned, very important, living and legal expenses. So first and foremost, not because I'm a lawyer that needs to be paid, but living and legal expenses are quite important for you to start with as a first point, because you need to know who's going to be paying you going forward. But that being said, engagement again becomes very important with your investigating officer to try and trace back, because one of the things that gets lost in translation at times is that your client is still under the protection of innocent till proven guilty. He has a right to actually go and prepare for his defense, and in so doing, he needs certain resources to do so. The allegation might be, and the test, as case law has proven, is that there's suspicion that these assets are the proceeds of a criminal activity or are being used in the prosecution or the progressing of criminal activity. Now, that's still an allegation. That's where my mind goes and says, every time when Chuma was saying alleged, I kept saying to my mind, alleged. But the reality being is that you need to distinguish then between someone that has already been convicted and then the process to forfeit is actually being triggered, versus a position in which you are trying to restrain, which is similar, and when I try and explain it in the truest sense of civil law, is similar to how you use an ant and pillar to preserve documents. You know, now you're dealing with a criminal process and a criminal investigation. Obviously, these are assets. The immovable assets are quite easy because you can't really move them, and obviously the deeds office gets cited, so it's not easy to move those. But where you sit with immovable assets, and obviously with monies as well, we were talking with Chuma earlier even about money mules as well that get used to transfer to different currencies to try and dispose of assets. One of the things that then becomes important in your engagement with the stakeholders, and I'm going to use for purposes of this discussion, at least for now, until the Q&A, the NPA, is that you need to go to the value chain, because when you talk about the NPA, you need to understand that part of their case and part of their team is going to be your IO. So you need to, at all times, understand who the IO is, because before you go to the battle of Chuma disclosing what is in a docket, if you get along with the IO, chances are you're better placed to actually find out where they're going with it. Because why is the docket so important? Well, it's going to give you the scope. Are they overreaching? Are they going beyond it? Because one of the good things about poker is that there's as much as I don't agree with it as a defense lawyer, I must say, is that you sit with a situation where
you are actually kept to the assets that are in line with the unlawfulness, with the alleged, and I'll keep using the word alleged, alleged criminal proceeding itself. So I could have been Sentebale working at CDH and having my earnings, and I'm staying in a house that I can justify with my CDH salary, that I'm actually in my vehicles and everything else, including anything else that I might be owning. But now that's where the docket then becomes important, because once you understand the scope of that docket, it's easier for you to answer and be able to go to court and say, actually, as much as the order has been made, I actually am asking for it either to be discharged, but in the alternative, can it be varied? And how will it be varied? Can you look at my expenses? Here's my bank accounts. Here's what I can demonstrate and justify at this point in time. Well, usually we do it in two phases to say, well, we're doing it in leg one to prove these, but because of the march, it's immediate. Now, with your bigger corporates like your mines and everything else, there's other stakeholders involved. Your unions start getting into the play because employees need to be paid. There's also a bit of an abruptness and disruption in the business, because as soon as a person like Stephen comes in, the board is low, its powers are also now starting to get affected. In actual fact, they're non-existent as soon as you get into play. So all those actors need to then start understanding within their powers and value chain what they need to do. And also to be able to unpack more so with regards to your solution in regards to that specific tailored solution. So working with a common alleged drug dealer, which I'll probably never act for, but let's work on the basis of a mine with, like one of the things we had encountered before, where there's mining ore that's actually not being registered and it's actually leaving the country illicitly. So it was basically SARS coming in and saying, you've not been disclosing your tax properly and everything else, but all in all, NPA gets involved, and it's now sitting in a situation where you have this mine, there's the stakeholders, there's employees, there's corporate governance issues that need to be happening. There needs to probably be, in the good best practice, you probably need to take someone like Stephen with the people there and actually have them, because most of the time people want to first understand, am I losing my job in all of this? But secondly, understanding that in the South African context, that it's only the assets that are linked to the criminal or alleged criminal activity that are actually at play. Now it's a matter of us trying to dissect and remove that which is legitimate to those that are alleged to not be part of a legitimate process. And the obvious thing then would be statements that come into play. For me, for example, would be my colleagues that would also provide statements about my sources of income. If I've got a side hustle, I'm selling Inuka or Forever, also that gets disclosed, you know. Side hustles, guys, it's VAT is increasing. If you ever take anything, side hustles are very important. But that being said, but you're also looking at, in that process of doing the statements, you're then disclosing your bank accounts. Now, as Stephen has eloquently said, they've already got a forensic accountant on their side. Chances are you probably also need one as well. So when you then start also drawing up the living and legal expenses, motivations, and you're probably going to do it by affidavit, it's always a good idea to maybe have that first meeting with them before you actually just start filing, so that you actually know what is actually going to be challenged versus what is actually going to be something that they're actually going to agree with you on. For example, things like school fees are usually things that people tick a box on, so at least you know where the fight is, so to speak. Yes, there's going to be a couple of rounds of maybe going to a magistrate where relevant to try and actually increase. And obviously, as a lawyer, you're probably not doing enough for your client because he feels that he needs that specific car or anything like that, as Stephen probably would tell you with many of his stories as well.
But I did say he can drive the Beetle and we'll take the Ferrari.
Aesthetics. Aesthetics are important. There's actually an argument once we presented on the basis of business and understanding also aesthetics of business, that unfortunately the car that they wanted my client to be using, which he had actually bought for his son to use in university, which was a Polo, he then said that it does cause a disruption to his normal business, because what we had then tried to do there, luckily it wasn't something well publicized where it was in the public media. But there was the element of trying to limit his reputation and dignity, because remember, the Constitution's still at play in all of this. So while he's still innocent until proven guilty, while these are all still allegations, you need to minimize the discomfort and the intrusion on the person's life as well. Now, from graduating from being a person of interest to actually being a suspect, in all that process, obviously with a lawyer, you try and actually minimize any disruption there. And I'll explain why, for example, the issue of the car became a problem for him. He said he was a church leader, and part of being a church leader, but more importantly, in society as well, he's seen as a certain person. It also instills confidence in the kind of businesses that he does. What car he was driving was an S-Class, beautiful car, and it made sense to me why I needed it. But
I'm not sure that would have made sense to me.
But the point being is that you have those kind of arguments at times, and as much as we're creatures of instructions, but you'll have those arguments where you say that, well, we understand that it's, to certain people, a car is a means to an end, for example, on a practical context. But there the argument was more on the basis to say that these are tools of my trade. Tools of my trade in the sense that my aesthetics matter. Now, for example, if I start rocking up in a polo, it starts raising certain questions. In the agreement that there's still allegations here. These allegations, if known to the market or if known to my stakeholders, would have a ripple effect on some of the agreements that I have. I'm a CEO, I've got a morality clause with my group. The group happened to be an American company where they had a morality clause, where it was written in such a way that even an allegation on an NPA process would have actually triggered that process. So it then becomes important to try and close off the chain of communication between the NPA and also the various other stakeholders, like your IO, for example. There, for example, there was a SARS element because of the illicit transfer of ore from the country, that we then had to actually have sort of a closed session. It actually, most of the time, I can't remember a time when we actually would have submissions made in open court. It was always in chambers, or in magistrates' chambers as well, where we'd always have these engagements. What then becomes important on it is that, as I've said before, those are the peaceful ones. Now you get the Chuma one on the other side, where it's not peaceful. You are, after the fact, you are basically doing patchwork, where it's now a situation where the assets have been recovered, have been preserved, for lack of a better word, of being restrained for purposes of Chapter 5. Is that you're sitting with a situation where one of your first tasks is to actually make sure that what your client says should be there is actually there, you see. What was strange most of the time is that you get resistance to find out, because one of your first jobs for your first 48 hours is finding out where everything has been stored, and actually having to be allowed, obviously with the chaperone of an NPA officer and obviously SAPS, to be able to do your own inventory of what is there. Because what happens at the tail end of these things is that you'll find yourself, because people become very petty when they get acquitted and very confident. I've found myself having to go and file for Carol Boyce and La Crusade, you know. So those are things that happen where you found the car and everything else. So the inventory becomes very important for your own purposes practically as well. But then in the situation where there's a curator already appointed, it also works well for you to then be able to sit and compare that specific inventory. Then it's the matter of then rushing to court. Again, the argument is always, most of the time that you run to court is going to be the living and legal expenses that you're coming in, because either you're asking for a discharge. The only time usually when you get a discharge is because it's linked to the allegation itself. So if you prove the allegation and what they were suspected of to be discharged, then usually as a consequence, your next thing would be then to ask for a discharge. By the way, it's an ongoing process. We're in South Africa where it could take a while for that to happen. That's when you then have to then look at variation, for example, to say that I hear all is well under the sun, but I'm asking this to be varied. School fees, as we've agreed with Stephen, that you can accept that. Might not be a Ferrari, but S-Class, structural integrity, German engineering.
That applies to Volkswagens as well.
But the reality of it is that there's no hard and fast rule. It's very factual, as you probably would have seen with my example that I'm using, about what actually these living and legal expenses. Legal expenses are very clear. It's me and my counsels and what we are doing with them. That's usually what happens with that. But even there, you can't be frivolous, you see. There's certain things where you'll get cost orders against you, and more likely than not, many a times you'll actually get a cost order against you as the attorney, understand, on certain things, because he's already under advisement by that time. So courts do frown on you asking for silliness as well. But where it becomes important is to try and preserve that which the person, because you're working on the basis to say, on the innocent until proven guilty. Section 35 realizations. So there needs to be that balancing act. The balancing act means that if that person, it's a different case if you're talking about someone that's not been granted bail, that's sitting in jail. But even there, that person has dependents that are still awaiting. So sometimes your application is not necessarily for his benefit. It's for the benefit of the dependents. And what you look at, I must say though, I have not encountered a time when, for example, it became of relevance to go to the people's closets other than just to search. So I do think that for at least as long as I can, I would preserve the Louis Vuittons and everything else, because at least the person needs to look good. You can't be looking terrible in court. Then you start looking guilty. But again, I think with the examples you get is that there's no hard and fast rule. What you're dealing. I always say there's a lot of human element in asset forfeiture. The human element in it is that depending on how you've started this thing, if you come with it, do you know who I am attitude, you are in for a very long and difficult process. But the demeanor that you take in with regards to engagement and actually being able to follow the process, but also respecting your colleagues on the other side to understand that the main aim here is to preserve. In the event that there is a conviction, when the forfeiture happens, these assets still exist. Now, there's some assets, for example, that lose value over time. So it's within those interests as well that you start also building the argument to say that it's definitely not in the state's interest to keep these assets as long as they are. Now, there are times, for example, properties can be rented out. There are times when properties can be sold. But it's usually better at those times when we are all at peace, where we can actually negotiate on those and agree and then put them aside and say, okay, fine, now we're working on monetary terms and we're working on these sitting there. Now, the problem with many of the times that the practical things that happen in the background outside of Stephen and the NPA is that sometimes these properties are bonded and the obligation doesn't suspend. Municipal rates don't stop. You see, there's a lot of these other things that start coming in. Many of them Stephen will pay for, but what happens when Stephen can't find a tenant? You see, so it's those kind of things that then start kicking in practically. Yes, it's an invasion of your privacy, of your freedom, and your use of things that you've enjoyed, pending you actually being found to actually be guilty. But where I always work on the premise that it's still an allegation, and while it's still an allegation, then it's still alleged assets of a criminal.
Thank you. I must say I was intrigued when Sentebale was referring to the cooperation and he didn't like the surprise element. But the reality is that when the crooks know you come in, they start to hide, they start to conceal.
Alleged crooks.
Alleged crooks, yeah.
Colleagues, I think this will be the time for questions and answers, but I think let me tap into two things that Sentebale and Stephen mentioned. Sentebale mentions a very critical aspect. We're all officers of the court, and we do have different interests in terms of who we represent, but 90% of the times, we're not fighting the fight because we're fighting the fight or want to fight with each other. There's interests that we represent, but in 90% of the times, if you come and approach us, things that don't get to be as difficult as you think they will be, and it becomes even more easier when there's a curator in between the two of us, like this. Indeed. Because if you come with certain allegations of expenses, I don't have to be hyped about it. I'll just refer, Stephen, can you investigate this? She's asking for these living expenses, tree helpers, whatever. Okay, Stephen, what is reasonable? Stephen will say, okay, I know what's the house looks like, you know what. Tree helpers, Chuma, no, we can't pay for tree helpers. But at least 2 is reasonable. So when there's a curator in a matter, other people will come up and say, but the curator is going to be paid out of this estate. Yes, that's the case, but at times it does help because there may be some stalemate between the two of us as legal officers, but Stephen might be able to bring in some objectivity and some sobriety to say, we can pay for this. We won't lose anything. The estate is still looking good. We can cover 1, 2, 3, 4, 5. So Stephen does play that neutral role between the parties as well, to be able to look, are we very much unreasonable? Are we being unfair in certain instances? He's able to quickly investigate all your claims of the list of things that you're claiming to incur on your application and be able to say, this is reasonable, this is not reasonable. So that's why Sentebale was saying, before you even lodge an application, have a meeting with us. Let's look at what you're looking for. We'll be able to tell you, on this one, no, we won't agree. Then if you still want to go through the court process and push for the fight on the application, that's okay. But in 90% of the times, we're reasonable. We're able to say, this will not agree to it. This is fine, we'll agree with it. And with the help of the curator, they are able to investigate certain things. Do you really have to incur these expenses? Is it really necessary for you to incur? So that there's a bit of a balance, and with time and improvement in the asset recovery space, we'll look at options. For instance, we'll look at some big cases, and we realize this case is going to take long to get to finality in terms of the criminal prosecution if it's a restraint. And we time our restraint. We don't start like in the olden days, as soon as there's an allegation and whatever, we jump into a restraint. And we assess the individual as well. We look at the individual and say, this person has got a lot of assets, has no risk of dissipation here. We don't even have to go for a restraint. If the criminal prosecution is going to take long, we'll wait until it's finalized and just chip in terms of a confiscation. So we do assess our cases very well. We do also assess the individuals we're dealing with. And in certain instances, the benefit is even lower than the assets that you have. There are individuals where we look at their asset profile and say, okay, my benefit is 10 million, but the individual has got assets to the value of 60 million. So why must I stress myself and go for a restraint? So those are the things that we balance. We also look at targeted restraints. Like if the individual, the accused or the defendant is still employed, is able to pay rates and taxes, I don't have to take your property. I just put certain obligations on the court order to say, remain in the house. Report. I will not be taking it. It's under restraint. Just service, make sure that you pay the rates and taxes. So there's no disruption as far as you are concerned. So I think with time, we're able to come up with innovative approaches to how asset recoveries can be utilized to the benefit of everybody else, and not to be seen to be like we want to deprive individual, almost of everything. Then unless it's a Chapter 6, then it's just proceeds, clear proceeds, then that's something else. But if we're dealing with Chapter 5, there's still scope for certain things. Thanks, colleagues.
And just before we open for questions, I just want to also convey, as a curator bonus, you step into the shoes of the subject of the order, and depending on what type of business they run, it becomes quite challenging. So as a lawyer, suddenly you're running a mine. The most challenging one wasn't my own matter, that was a colleague of mine, and the asset forfeiture unit got an order against a strip joint. And my colleague had the dubious distinction of trying to keep his business alive. But it is difficult, and I think, Chuma, you hit the nail on the head. I've got to be rational, I've got to be reasonable and conservative. So I'm still not convinced on the S-class, but I'm literally the balance between AFU and the defense attorney, and I'm very mindful that whatever I do, I'm going to be sued if either party doesn't like it.
No, you'll definitely be sued.
So we try and find a happy medium most of the time, and then when the requests are unreasonable, we put our foot down and we say to Sentebale, go to court. And all the cases I've been involved in, the judges have said, Mr. Powell, you were eminently reasonable.
No, I think just maybe before we get into questions, is that it goes back to what I was saying, that it's all about the consultation process. It's about talking about these things. Like, for example, myself and Stephen are not mining executives, you see. But what I can do is that I'm now a conduit between what the person of interest would be, the accused would be, and say, whom actually do you recommend that can come and actually be of value to Stephen? And those are things taken into consideration to limit the disruption. And also, it's a very important thing because one of the things that happens when people are criminally charged, in a way, is that it does have a ripple effect on their personal. What people don't deal with is that when the person is eventually acquitted for whatever reason, probably maybe I had something to do with it, but is that the consequences of that on their business and their recovery from that becomes a problem, you see. So that's what you're trying to always, also at the back of your mind, try not to infringe on as best as possible. It's not always a hard and fast rule. But the last thing you want is a situation where a business was thriving, it goes into asset for a restraint process, and then when the curator hands it over, now you're sitting in a situation where you have to go to business rescue. You see, so those are some of the things that you need to consider, because there's an asset here. How much of this asset, if at all, is actually part of a criminal activity?
Okay, I think, colleagues, we've said a lot, and I think let's allow some questions and answers. Do you have a roving mic? Okay, there is Portia with the roving mic.
Thanks. I have a question for you, Sentebale. Chuma referred to a Chapter 5 process, Chapter 6 process, and you spoke about the Chapter 5 one, I assume. Do you deal, or how do you deal with a client in those circumstances where there's a Chapter 6 order?
So, should I take, let me rather answer as I get questions. As I said before, for whether it's 5 or 6, the reality is that for one of the first things that I need to look at is legal and living expenses. Because the restraint itself, remember on the one, there's a criminal process, there's a conviction. On the other one, it doesn't require a conviction. But the consequence for the person whose assets have been restrained or preserved means that they can't use the assets the way they would have used them but for this order. So one of the things is either I need to discharge that if it's in the criminal process, or I need to now vary in order to mitigate the impact of the specific order. And there's a various reasons depending on the facts. If you're talking about a mine, the continuance of the mine with limited impact on the business thereof would have to be to the core. If you're dealing with an individual, for example, that has been accused, for example, by their company, they've already been suspended at CDH, but now the company wants to preserve their income, for example, or what they believe to be monies that have been sourced from an illegal activity, is then to be able to look at that and see what of that will be able to give that person an opportunity and the funds to be able to go and actually level a defense and be able to face the accuser. So it depends. But what I always consider is, at least from my side, is whether or not, first and foremost, do you have access to your assets, but there's also the bigger defense in mind as well that has to be linked, because usually as things graduate in the defense itself with postponements, or for example, at times when we actually ask after the prosecution has closed its case, that actually maybe let's talk. Because remember, even in the criminal process itself, as and when witnesses are being called on a day-to-day, there's certain things that make every other side, whether Chuma or myself, nervous. We start talking on those things. And maybe at some point in time, we then say, maybe we actually have gone too deep in this. It's time to maybe withdraw. So it actually depends.
Maybe I can tap into that one way or the other and try and give some clearer picture. Let's take an example of a mine. A mine has got employees. Those employees, let's say it's proceeds of crime, this mine. It was purchased with money from criminality and
Alleged.
whatever. Okay, alleged criminality or whatever. Okay, that's a Chapter 6, purely. That's exactly where your question is.
Civil, yeah.
Now, I had indicated, with the risk of higher employment in this country, I'm mindful to certain things. My interest is not like those 200 employees there in that mine must lose their jobs. Supported by Stephen in his role as a curator. There may be other people who even want to buy the mine and run with the mine. those are the considerations and the discussions that we get to have along the way, because the issue is the mine is still viable. Stephen should be able to tell me, is the mine still viable to be run? If Stephen says the mine is still viable, we need to keep the mine open. Those are also my considerations. I'm not seizing assets to destroy livelihood of people who are not involved in the criminality. More especially if there are third parties who are interested in running the mine, who are interested in taking over the mine. In certain instances, we even come to some agreements to say, you know what, let's finalize this matter, the sooner the better, because we've got somebody who's ready to take over the mine and ensure that people's livelihood are not affected. So certain lawyers will be difficult in that, others would appreciate to say, this is not all about the client who has been involved in criminality. There's 300 people who are going to lose their jobs if we keep on fighting like this. And those are the things that we end up considering. For instance, in certain instances like business that are still viable to continue and to make sure that people don't lose their jobs.
So not to hop the mic, I just wanted to find out whether there's a difference in your defense where a client has not been convicted of a crime, because you are preserving assets of a client that's not been convicted of a crime, and the alleged is actually, I assume, not even an issue at the time.
So the distinction would be from a convicted person, it's the people left behind most of the time that have an interest in the assets, because they have a certain lifestyle. Their school fees still go if daddy is in jail or mommy is in jail. You see, there's other interest in stakeholders, there's businesses that were continuing, that were unaffected by Sentebale's criminal activity. You see, that still need to continue. And that's where the interest, for example, on 5 would actually come in. Now, on 6, on the other hand, the actual person's interests are also very much at play, because he still needs to go do his defense. He still needs to, with limited disruption to his normal, still be able to answer to his accuser. That means that, and as I've said, I've used the example of the Polo versus the X-Class. Those aesthetic considerations where someone says to you, as part of what I do in my business, as soon as this drastic change happens, there's going to be suspicion. It's going to affect how people deal with me in business. It's going to make me lose my contracts. It might trigger certain things, because then it's going to start amplifying and actually announcing to the world that there's actually things of suspicion of impropriety towards me. You see, because you always work on the premise that at the time, if for example, this person is to be found to not have a case to answer, to have been acquitted, for that person not to have a situation where they are sitting now and having to go on business rescue or on liquidation because of a process that needed to be followed in order to find. Remember, prosecution is a fact-finding mission. It doesn't gun for the person, it guns for the commission of a crime.
I think my colleague is looking for what defense you might have in Chapter 6. And we have what we call an innocent owner defense, where you want your interest excluded, because this property might be proceeds of crime, but you bought it legitimately.
Indeed.
I mean, and or they say it's an instrumentality. Instrumentality is issues like drug labs. You are the owner. You've actually rented the house out. Somebody is conducting illegal activity. So your benefit, it's basically called an innocent owner defense. So once there's Chapter 6 against your client, you go for after preservation. That you can do after preservation. So you can anticipate the order. Before they even bring the forfeiture, you oppose it on the basis that you are an innocent owner. So your client can say, look, exclude my benefit. And you need to show that you actually got that asset for consideration. Because mostly what criminals do, they donate to the aunt, they donate to the aunt cannot show. Yes, the property is registered in their name, but they did not give any consideration. So for you to succeed with an innocent owner defense, you need to show that you actually got that asset lawfully. That's basically it.
And just to add, the orders themselves, the preservation orders themselves actually do have a period in which they say, because most of the time they're done on an ex parte basis. So they actually do anticipate that if there is someone with an interest that can come up and prove and demonstrate that I actually am the true owner of this property, or for whatever reason, this car was actually, the perfect example, like a Masumlusi Gigaba situation where the SUV was not his, it was someone else's SUV. That person comes and says, actually, this was mine, I had loaned it to him, thank you very much, can I have my car back? It's those kind of situations, but it's more understanding that from the time that it starts, that the preservation is now in place, you starting to engage. Sometimes it's actually always pleasant to go to court having agreed amongst ourselves, so that when you actually do anticipate the date, you don't even wait for it. We are now going to court just to clarify that these must be excluded from Stephen's list, for example.
Sorry, my question is for you, Chuma. To what extent is the exclusion or the innocent owner defense something that's negotiated before even the grant of a preservation? You know, and the reason I ask is I was recently involved in a matter where there were several plots that were the subject of unlawful instrumentalities of an unlawful offense, and we managed to get a preservation order in respect of those properties. But what was exceptionally frustrating is that there was a lot of back and forth with the MPA about the exact nature of the property that was going to be subject to the preservation order, because several parties had raised an innocent owner defense. So to what extent is it something that is really just the subject matter of engagement? You're an innocent owner, go to the MPA, I've bought this innocently, please exclude it from the list. Or is it something that happens after? And it really helps just to understand that from the perspective of, you know, you're walking in as a litigator, you're doing something very serious, you're getting an ex parte order in rem against property that somebody says is mine and I acquired innocently. So I need to know what the property is, you know. Thank you.
Okay. In terms of our applications are ex parte. So before the preservation, we obtain the preservation order. The likelihood you won't know that we'll get an order until you get served. Okay? So we've done our assessment, we've established the act of unlawfulness, we realize that this property's procedure is instrumental, whatever that is in terms of Chapter 6. We get an order, we serve it to you. That's when you'll be able to bring up your defense now. But the likelihood of you coming before a preservation, that's non-existent or slim.
So you've put under preservation several properties.
Yes.
Preservation order is granted, innocent owner comes now. So
Yes.
what is subject to the forfeiture order can be different from what was subject to preservation.
Yes.
Yes.
Yes. So now what happens is that the moment then we get a preservation, you get to be so you get to be aware now. You come up now with your application. You are on notice in terms of Section 39. You place yourself on record to say I've got an interest here that needs to be excluded, like Jacob is saying, or you are opposing the full application, whichever way that is that you're dealing with. Immediately you raise your hand. We go back to our facts. We'll look at your story. We investigate your story. Okay? Then, if we are satisfied where we are to say, whether you're claiming to be an innocent owner or not, from our perspective, you are not an innocent owner. That's a full opposition. Let's go to court, let's go and fight. That's it. But if we realize that through your defense, we go back and investigate, we realize that your defense is reasonable, possible, true, then we will go through the process and exclude your interest at forfeiture stage. So you don't get to be affected by the forfeiture order.
My situation was very interesting. The reason why I asked whether it's possible pre-preservation is because in that instance, there were several preservation orders that had expired And so, of course, we couldn't go to forfeiture stage. And during the past proceedings, these innocent owners had come forth. And I think that's where the difficulty arose with the NPA.
Okay.
In previous processes where, the 90 days has expired, the forfeiture order wasn't brought, what do we do now in this new process? Because do we exclude it right at the beginning from the preservation stage when we were informed in previous proceedings that, I'm the innocent owner?
Now, this is what happens. If the preservation order lapses, and I still have a case, it has lapsed, I've got one option, is to reinstitute. So when I reinstitute now, it's no longer an ex parte application. It's no longer because I have to give notice to you.
It lapses.
Yes.
After the 90 days, do you not have to bring a new ex parte?
Yes. I reinstitute. I would
wouldn't
call
be
it
ex parte,
reinstitution.
No, it would.
It wouldn't be expired.
But it will be on notice now because
immediately
it's
a notice,
no
I'm already
longer. There's no longer risk to the property. There's no longer risk to the dissipation of the property.
So the ground for the ex parte is always on the basis that you're stealing a march on me because I might dispose of the property.
Yes.
So now that you've actually exercised the preservation itself, practically it means that at the lapse of the preservation, those assets are still in the custody, for example, of Stephen at that point in time. So it's a matter of me now, either if they don't do anything about it, writing to Stephen for those to be returned. But if they, for example, are going to now relaunch at that point, they would then need to serve on me. Because one of the other things that happen is that, remember the test, the test is either, was this asset an instrument in me doing a crime, or is it actually the proceeds of an unlawful activity? Now, it might be, out of the 5 assets that you have seized, 2 of them don't fit that criteria. So in the next application they do, I would then, as I've said before, that one of the things is either you can discharge or you can vary. One of the things that you would actually do in a reinstitution is to exclude from the onset those 2 properties. To say, let's not talk about these. The ones that are actually in question for your purposes are only these 3. So we can't keep doing the cycle where you take all 5 and then every time I must come and prove the 2. You see, so that's how it actually works practically, or in the ideal world. Yeah.
And the moment you reinstitute, after your preservation has lapsed, no court will ever allow you to come back ex parte. You have to give notice now. Because you at that point in time, you were worried about your dissipation. But you same now, you still worried about dissipation after you've allowed your order to lapse for 90 days, you decided to sleep. And then now you still want to bring it on an ex parte. The court is going to jump and say, you can't. You can't have your cake and eat it, and you sleep and you come back and you say, this is still. The moment you reinstitute, you have to give notice.
We were on our 4th preservation and we brought it ex parte before Justice Jaja, and she granted our preservation order ex parte.
Clearly I was not the lawyer.
You are not.
Any other questions? Yeah.
But we can take it offline, it's okay.
Evening everyone, Angus McKenzie from the Johannesburg Bar. Thanks to all the panelists for making yourselves available. It's been a very interesting discussion. My question is mostly for Stephen and also for Chuma. I have a problem. Stephen, you clearly are an experienced attorney and you understand your duties to sort of both parties, if I can say it very well. But in my experience, most curators are not you.
Exactly.
They are sometimes auditors who, that's fine. Often, they are retooled liquidators and business rescue practitioners who,
syndicates.
You're getting where I'm going to, Sentebale, where ultimately, whatever the legislation says, they know that at the end of the day, their appointment for future estates rests on the NPA's decision, because the NPA doesn't come to court with a range of curators for the court to appoint. It says, this is our suggestion here. It can be Mr. Hills, Mr. Powell, whoever it is, and the court will appoint that person on an ex parte basis. don't we need a third party appointing the curator? I don't know sort of who it is, but my feeling, my sense is that needs to be taken out of the hands of the NPA, especially because from what I see, most curators, they won't say boo unless the NPA tells them to say boo. So the person subject to the restraint can come and say, I need this, I need that. The curator will say, let me ask the NPA. There's no application of their mind to whether it's reasonable or anything like that. And if the NPA says no, the curator says, I'm going to be conservative. I'm sorry, you have to go to court. You've got no access to funds, of course, but you've got to go to court and get an order compelling me to release anything before I do. So, yeah, my sense is, look, isn't there some legislative reform that needs to happen around the appointment of curators, or isn't there a lacuna there for more safeguards that need to be built in?
You know my view.
Especially because at the end of the day, you're not a mine owner, anything like that. Yeah. If a person is discharged, and let me just say, I've been incredibly unsuccessful at getting restraint orders discharged. Your best bet is either you're going there that there's been failure to disclose, or you might as well just agree to the restraint order. So what you're looking at then, really, if you're subject to the restraint, Chuma, is if you are discharged, you only get your assets back 5-6 years. Obviously, I'm talking about Chapter 5 now, not Chapter 6. It's been in the hands of somebody who doesn't know how to run your business. There's no loss of profit claim against a curator, just at common law. The bar to that claim is very high, but the bar to a restraint order is very low. So again, I'm saying, isn't there, I feel like there's a bit of an imbalance there, and yeah, do we not need a bit of legislative reform around the roles of curators, particularly in asset forfeiture?
More appointment.
I think that's a very valid observation that you've made. So I don't know what the solution is, and I don't know what the NPA's response is going to be. But for me, the yardstick was always, am I being reasonable? Is this in the best interest of the state? So I would look very cautiously at that. And I think where you have career curators, I think that's a challenge.
Okay. I think from my side, my response will be, curators, they are not reporting to me. They do whatever they do. Remember, they are holding this interest at the end of it all for my benefit. But they don't have any obligation. They are under the control of the Administration of Estate Act. They have to ensure that they are doing their part in terms of the legislations that governs them. Whether that pleases me or doesn't pleases me, there's certain instances where I sit in certain cases where I'm not happy with the curator. And I have to bring an application for a substitution of that curator in court because of certain things. But it's not an application that I will do abruptly because I'm in disagreement with Stephen. Yeah. It has to have an element of recklessness towards the curator and how the curator is taking care of the assets. Remember, I don't want my institution to be sued at the same time, at the end of everything else, to say, these assets were not well looked after. So the only instance where I would even go to the extent of really going to court for substitution of the curator is when I realize that the curator is not taking care of the property. More especially in terms of Chapter 5, because everything is still hanging in the balance. There's a criminal prosecution. There's conviction that still has to come up. I'm not sure whether it's going to come or not. So I can't risk having a reckless curator. So the only instance where I wouldn't say I'll be unhappy with Stephen because Stephen is applying his law. Stephen will have to tell me, I don't report to you in terms of legislation. I've got my own legislation that governs me as much as you have your own poker, But at the end of it all, they are doing everything in consultation. I can't dictate to them. They've got a reputation and the integrity to protect at the same time in terms of their own obligations. But the only instance where I'll jump and really feel like is when I feel like the curator is acting so recklessly towards the administration of the estate. And when I feel like the estate is not managed properly and the estate is losing value because of the curator recklessness or carelessness, then I'm going to jump. But normally it's Stephen, we hardly interfere to that extent.
And
No.
for me, just acting as the curator, I'm reporting to court, so I always was very mindful that whatever I do, I've got to satisfy a judge that I've been independent, impartial, objective, and that I've considered the best interests of both the subject and the asset forfeiture unit, and done what is in the best interest of the estate. But I think your point is that's not your experience with all curators.
But also,
and that's where you need a robust
but also it goes back to, we've seen this in business rescue, we've seen this in liquidations as well. Unfortunately, the good ones are all being recycled the whole time. It creates a certain familiarity, and there is this perception, I will call it a perception at this point in time, that they, in that familiarity, and also because the appointment at some point in time does have the NPA's involvement, that to a certain degree, in order for the person to keep securing the favor of the next appointment, that they would now and again lean more towards the NPA. But there is recourse in that, because if you have enough, you can actually go to the same court that Stephen reports to and say, actually, this person is no longer impartial. You see, yes, there's a test, it's a bit more higher to prove it, but there is recourse in that. I do think there must be some reform with regards to the appointment itself, but I'm not sure how it would be fixed, because unfortunately it's a recycle bin of the same people. At best, the good ones, I won't lie to you, you'll always see them in certain level of kind of matters. It's not going to just be anybody else, and it does to a certain degree create a perception of biasness.
I remember one of the early ones, that Mohammed case, he brought an application to have me removed as curator, and he alleged in his papers that Stephen was a prosecutor in his former life. He's biased in favor of the state. And the judge said, if you allege bias, you actually need to show evidence of bias. Yes. And just because someone once worked for government doesn't mean they're going to be biased. But we had 5 legal challenges, and he challenged the legislation saying it's ultra vires, took me to court on my appointment saying I was biased. He wasn't happy with the wedding, and then there was a big fight around the quantum of his living expenses. He wasn't happy when I said you need to have one maid and you're going to have to drive yourself. But I think this has been a wonderful session, and lots of questions, lots of Q&A, and I think it's been...
Can we chat over a drink, guys, please?
Yeah, let's carry on the other side. Thank you.
Thank you, everyone. I think Sentebale has already beat me to it. The panel is still available. We'll be moving to the deck for some drinks and to actually finish up the conversation. Thank you so much.